Back with you tonight here on In Focus. Chief Justice Raymond Zondo is found against Public Protector Advocate Busisiwe Mkhwebane in her challenge against alleged disclosure of confidential information by alleged judge colleagues to consult Ismail Abramjee. Mkhwebane had argued that the exchange had related to her contest against rules governing a forthcoming parliamentary impeachment inquiry against her. This follows a dismissal of her application earlier in the month for a rescission or setting aside of the rules governing an inquiry into her fitness to hold office as public protector. Mkhwebane had then sought to hold the inquiry until the conversation with Ismail Abramjee's text to Parliament's advocate Andrew Breitenbach were finalised. Now, in this vein, she revealed that 18 calls had been made from a number with the controversial SMS to Advocate Breitenbach, and one registered under the name of Judge Jody Kollapen and another belonging to Acting Justice Dunstan Mlambo. Joining us now to explain what the latest developments against the Public Protector mean for her prospects against the impending inquiry is Judges Matter Coordinator Alison Tilley. Alison, good evening and thank you very much for your time. The question, of course, is around whether or not there was this leak and how important is it to get to the bottom of this leak and where this leak came from.
So I think there are so many different issues going on here. It's difficult to separate them all out. Certainly if there is an issue with the conduct of a judge, the correct way of dealing with that would be to approach the Judicial Services Commission and lay a complaint in terms of the, failure to abide by the Judicial Code of Conduct, something along that lines. It's not clear to us that the Public Protector really has the jurisdiction to proceed against judges in this way.
Yeah, as far then as the route that she took, I mean, initially she wanted to do an inquest and subpoena judges, but of course she later turned on that particular idea because the judges, of course, refused to cooperate with that. What then does that pattern reveal again about the Public Protector?
Well, I think we are in a situation where, and it's not just the Public Protector, but there is a consistent argument that judges are failing us, judges are captured, judges are doing improper things. But this is being done in the context of very little evidence, if any. And I think that is really our thinking about the JSC as being the correct approach. If you have a concern about a judge's behavior, it's really the appropriate thing to do is then approach the JSC and bring a complaint of misconduct. And that then has to be dealt with. There are numerous complaints in front of the JSC at the moment. And of course, whether those are being dealt with expeditiously is another question. And we would probably say not expeditiously enough. So it's not a panacea, it's not a silver bullet, but it certainly seems to us to be the appropriate way to approach this issue.
Yeah. Now, of course, the Public Protector initiated her own investigation into a matter, of course, that implicates her. She has now said no, she's closed her investigation into the SMS, which, of course, she is preempting the Constitutional Court's involvement in this particular matter. The fact that it is closed, firstly, before the Chief Justice finishes his investigation, but also the fact that the Public Protector literally conducted an investigation in a matter that involved her.
There's a very serious question around a conflict of interest here, and I don't think the Public Protector can avoid an allegation that she really was trying to sway decisions and events in her favor. Again, I think that's why the approach to the Judicial Services Commission would have been much more appropriate because, it would have been an independent, neutral third party and not directly involving the public protector. So, it was overreach from our perspective.
Yeah. Are you satisfied with the explanation that was given by the judges as to the number of calls and the kind of communication that was going on with the so-called contact Ismail Abramjee?
I think those are, it's what the judges have said, and we would without doubt accept that what they said was true. I think it does raise another point, which is the involvement of judges in anything which isn't judging. And I think we've raised this in other contexts before. It's really, judges should be speaking through their judgments, and it's difficult, I think, for judges to be involved in these issues, and they really, have to mind their P's and Q's in order for people to be confident that they remain neutral, at least independent, and able to hand down decisions without fear or favor.
Yeah. As the public looking at this, you're saying we shouldn't be concerned about those kinds of conversations?
No, I think we should be concerned, and I think we should expect an inquiry, and I think we should expect the Chief Justice to give us an indication as to whether this does or doesn't constitute a breach of the Judicial Code of Conduct. So in that sense, certainly we would, if an allegation is made, it must be investigated and the results must be made public. So there's no question about that.
Yeah. The fact that the findings of the Constitutional Court during the appeal of the public protector actually almost confirmed what she had already said that was going to happen. Is that problematic in any way? And maybe had a different finding came out, it would have started a completely different conversation for us.
Well, it certainly would have, but, frankly, we all make predictions as to the way that the Constitutional Court will rule. And, if it's an issue in which the facts are clear and the law is clear, we may well be right a lot of the time. That doesn't mean we have inside knowledge, and it doesn't necessarily mean that the judges have leaked information. It simply means that we have independently reached the conclusion that we think the court will, and the fact that the court does subsequently is something that actually confirms that the rule of law is operating, and the court is operating independently and making decisions in terms of the law that we all understand and agree.
Yeah. Once again, I suppose it's that big conversation around the independence of the judiciary in such matters and in the politics of this country. Can we be at ease about the distance that is being created between the judiciary and the politicians? Is it a healthy enough distance?
I think we should never be at ease in relation to the independence of the judiciary. It's a saying that the judges have no purse and no sword, and by that it's meant that they have no budget to implement the decisions that they make. They don't command an army to implement their decisions. I think we constantly have to think about how independent judges are able to be and how their decisions are enforced. And that really adds up to the question of whether or not we have the rule of law. And I think most people, and perhaps I'm being optimistic here, but most people would agree that the rule of law is really the best option for a society, and particularly a democratic society that is governed by a constitution. So I would argue in favor of making sure that judges' decisions are respected and implemented.
Alison Tilly, I appreciate your time. Thank you very much for coming on tonight here on In Focus. Of course, the matters that the Chief Justice indicated today that the investigation that he initiated regarding Mr. Abramjee's SMS is close to completion, and is contemplated that this will be completed by the end of next week or in a few days thereafter. And of course, we'll bring you that outcome when it comes out. Coming up